this is a variation of a speech I've given, a couple of times, usually to the state bar, advanced course, or some CLE, some continuing legal education program. But I thought it might be interesting for our viewers to kind of be educated on how I educate lawyers on final argument. And so with that, I'm just going to walk us through a speech that I would typically give to a specifically lawyer-centric audience, typically an audience that would pay money, not me, but a state bar organization or a bar organization, and see if I can kind of give the viewers a behind-the-scenes curtains on how I educate lawyers, right, and specifically on final argument. So let's go there. And every lawyer thinks they can give a great final argument. Even if they've never given a final argument, they think they can give a final argument. And I don't know if I can give a great final argument or not. I've given some that I'm really proud of. I've given some that I'm not so proud of. But here's the point. The whole reason I went to law school was to stand in front of a jury on behalf of a citizen accused. I didn't go to law school to learn how to participate in a merger or an acquisition or for tax purposes or real estate. I wanted to be a trial lawyer. I wanted to be that guy. I wanted to be Gregory Peck playing Atticus Finch in To Kill a Mockingbird. That's the whole reason I went to law school. So that's who I want to be. I don't know if I am that guy, but that's who I want to be. There's this notion that great storytellers or people that present great final arguments are born. They're not made. They're natural. I don't know. Maybe that's true. Maybe that's not. I think skill comes from repetition and knowledge and experience as opposed to a birth canal. But we'll see. I think great storytellers are made. I don't think they're born. But this is an effort to help people tell a better story in final argument. People always ask me, how hard is it to prepare a final argument? What do you do? Let me tell you, there is no easy button in preparing a final argument. It takes a tremendous amount of work, at least for me. I've often said, only because it's true, I'm not a quick study. It takes me a while. I also have said, because it's true, for every 30 minutes, there's probably at least 30 minutes of a final argument. I probably have 15, 20, 30 hours into preparing that final argument. I'm not the guy who prepares the final argument, writes it out line for line, and stands in front of a mirror and says, "Good morning, ladies and gentlemen of the jury." Good morning, ladies and gentlemen of the jury. Ladies and gentlemen of the jury, I don't rehearse them in the static and manufactured sense, but I work on them. So as any lawyer that's any good at what they do will tell you, if you're preparing a final argument, you begin with that final argument at the very beginning. In other words, your jury selection, when you have your jury selection, when you were cutting your jury, you know the contours of a final argument. When you are giving your opening statement, you are relying upon the contours and sort of the bullet points in your final argument. You begin with the end in mind. Create a final argument outline. You sync it with jury selection. You sync it with opening statement. You sync it with the cross of a prosecution witness, with the direct of a defense witness. Every single thing I do in a courtroom has at least in the periphery, if not the gun sights, of a final argument. So it's not the alpha or the omega, it's the alpha and the omega. During trial, I'm a big believer in using butcher paper. Butcher paper, well, I'll just do a live action shot. So when I talk about, I'll get back over here to the dead. When I talk about using butcher paper in trial, this is butcher paper, right? I go to Office Depot and I buy a big stack of this before every single trial. During trial, butcher paper next to the witness, and I will make my points. If the witness says something favorable or something significant, I will write it out with a big, black, smelly, noisy magic marker, and I will try to capture and write out for the jury exactly what the testimony of the witness is. You've got to become good at it. You can't be a stenographer. You've got to capture the essence of what a witness says. It helps the pacing of your cross-examination. It helps the jury focus on your issues. But one thing for you viewers at home, make sure that whatever you write or say on the butcher paper is accurate. A jury will not forgive you at all for making false statements or inaccurate statements when you write it out on the butcher paper. I review those final argument notations every night with every witness. I'm editing my final argument along the way. In other words, every single witness on my yellow legal pad, if they say something significant, I will write out an F and an A on my legal paper when I'm taking notes. I will come back to that and use it in my final argument. In terms of final argument prep, different judges will act differently. How much time? You need to know this way before final argument. How much time are you going to be given? Does a judge require you to exchange your exhibits or your visuals that you're going to use in final argument before your final argument? Is the jury charge, or the jury instruction, is that read to the jury before the final arguments or after the final argument? You've got to know all these things. You've got to know your opponent. Again, I always rely upon the greatest legal documentary that's ever been created, is My Cousin Vinny. But know your opponent. They are creatures of habit. Watch them in other trials. Talk to them or talk about them with other lawyers who have tried cases. If you can't physically observe them in a trial, specifically in a final argument, find somebody that has. One thing that is a completely true ism is never underestimate your opposition. Never, ever, ever underestimate your opposition. That will get your client a sentence that your client doesn't deserve if you underestimate them. You do you. That is a picture of my mentor, Richard Racehorse Haynes. I put that up there to demonstrate this point. So Mr. Haynes was a true legend. That phrase is thrown around an awful lot, overused. I've heard it, applied to me, and I kind of grimace when I hear it because I don't think I'm a legend. I think I'm a good lawyer, but that guy was a legend. He was an icon. He was just a true master of his profession. But one of the things that I thought was cool about Haynes were those glasses and that pipe. That was kind of his signature. So being a young lawyer who had the opportunity to go to work for Mr. Haynes, I went out and bought glasses, even though I didn't need glasses, that looked exactly like Mr. Haynes. I bought a pipe just like Mr. Haynes smoked, and I came home to my now first ex-wife, and I said, with the pipe in my mouth, glasses on my head, and I said, "Who do I look like?" She said, "You look like an asshole." The point being, I was trying to be somebody that I wasn't, right? And even though that was an embarrassing moment in my personal life, spoiler alert, there would be more, I was trying to be something that I wasn't. You have to find out, young lawyers or old lawyers, what you can do, and what works for you is not necessarily what works for someone else. I always like to preach that if you are smooth, understand that. If you are weak, understand that. Acknowledge that. Tell a jury. The bit in My Cousin Vinny where the lawyer that the co-defendant has hired for a second that comes in and says the stuttering, what that lawyer should have done was tell the jury right up front, hey, I'm not as smooth as that prosecutor. I'm not as good as that prosecutor. They're eloquent. They have no impediment. They have no issues. They have no fear. I'm not as good. But my point is, if you have a weakness, tell the jury about that weakness. Share with the jury about that weakness. Be honest about what you're not good at. They'll forgive you. They'll embrace it. Everybody likes to root for the underdog, so don't be afraid to acknowledge or share your fears or define your goal. In other words, it might be an acquittal. Maybe the evidence is breaking very well for you. Maybe you're headed towards an acquittal. Maybe the evidence hasn't broken so well for you. And there's a lesser, maybe you're arguing for a lesser included offense. There's an occasion, although somewhat rare, where your goal, the evidence has not broken your way. Things are not going the way that you hope them to go. And you're looking for, instead of an acquittal or a lesser included offense, you're looking for a mistrial. Find out who you were arguing the case to. My belief, and I think the evidence and the data support this, in every juror of 12, you're going to have really 1, 2, or perhaps 3 people that are really deciding what the outcome is going to be. They're going to be the alpha male or the alpha female on that jury, and you need to tailor your final argument to whomever that alpha is. If the alpha is a banker, you're probably going to argue your case a little bit differently than the alpha is an engineer, or the alpha is a truck driver, or the alpha is a school teacher. Tailor your language, your focus, your cadence, your speech according to who the person that's going to be the decision maker is. Theater, it is hugely important in a final argument. Not only do I think it's important, I think it's mandatory. Robert Hirschhorn was our guest earlier today, and he was talking about the importance of theater. I don't think you have a license for proper theater in a final argument. I think you have a mandate. I think it's critically important that you get the jury's attention. Here's how I try to get it. I control the room. I make sure that I can dominate either physically, emotionally, or spiritually the essence of the final argument. I move. I vary my tone. I pause. I'm different. I'm loud. I'm quiet. I'm generous. I'm not. I'm aggressive. I'm passive. All of those things generally change in each final argument. I'm not the same monotone voice, cadence, speech, language throughout the 30 or the 45 minutes. It's got to be changed. You've got to have emphasis. You've got to have high points. You've got to have low points. You've got to have, the pause. As I've said before, pausing helps everyone in the room focus on where you're at. It is absolutely critical that you put some pauses in your final argument so it's just not a 30-minute drum solo. The picture there is a friend of mine who's an extremely good lawyer by the name of David Gerger. He's a master pauser. He really does the pause as good as anybody in the country. Visuals, they are hugely important in final argument. Studies will show that the older the jurors, more boomers you have on your jury, the less the visuals matter. They care more about the spoken word than the visual presentation. However, it's the opposite for Gen Zs or Gen Ys. So the younger the jury, the more important the visuals are. Studies will teach us that probably your retention of visuals is about 80% better than your retention of orals. When I talk to jurors about witnesses, I try to quote the witnesses verbatim, point out to the juries, their reaction when the evidence, came in when they heard it. For example, when David Greenglass admitted right after the lunch break that his story changes almost every time he tells it, I saw your reaction. It was at 6, it was at 12:15 on Monday afternoon, it was at 4:32 on Wednesday, whatever. I try to get very specific in terms of not only what they said, but when they said it. Think outside the box. What do I mean by this? When I was a young lawyer, I know that was 30 minutes ago, but I found out what worked for me and what didn't. I have given final arguments sitting in a chair. I have given final arguments when I was crying and very emotional. I have given final arguments when I'm outraged and upset. I've given final arguments when I was professorial and condescending. I've given all kinds of different final arguments, different types of final arguments to find out what works for me. What works for me is different than what works for you, but find out what works for you and not what works. I have always believed that a quote, you tell a jury someone else said it, you're going to have more credibility than if you just said it. So use the Googler. If lying was a job, I know some people that would be billionaires. If you tell the truth, you don't have to remember anything. Success has always been a great liar. Churchill, there's rarely a final argument that I give where Churchill is not mentioned, or JFK is not mentioned, or Kennedy is not mentioned, or Lincoln is not mentioned. I guess at some point I may have to mention Trump. That'll be hard. But the point is, a famous person saying something will oftentimes give you way more credibility in front of a jury than you saying it. What's great Churchill quotes. A lie gets halfway around the world before the truth has its chance to get its pants on. Once in a while, you will stumble upon the truth, but most of us manage to pick ourselves up and hurry along as if nothing had happened. A fanatic is one who changes mind and won't or can't change the subject. Lincoln, unbelievable in his repertoire. Look for the people, look for the bad in people, and you will surely find it. We can complain because rose bushes have thorns, rejoice because thorn bushes have roses. How many legs does a dog have if you call the tail a leg? 4. Calling a tail a leg doesn't make it a leg. Movie quotes. Round up the usual suspects. What we have here is a failure to communicate. Toto, I don't feel like we're in Kansas anymore. Now, these are some taglines that I often say in final argument. For example, some of you probably picked up on, I have kind of a bright, sometimes brash personality. I will inadvertently, not intentionally ever, but occasionally upset a jury by accident. I make sure to tell the jury something along these lines. Look, I've been in front of you for 2 days, 2 weeks, 6 months. I know myself well enough to know that at some point during this trial, I've probably done something that's offended you or offended your sensibility. That was the last thing I intended to do, but please do me a favor. And if I've done something that upset you, hold it against me. Don't hold it against my client. It's not their fault I did something that upset you. So hold it against me. Another thing I like to say is, this is the only trial my client ever had. Those of us in the criminal justice system, we become almost immune, or at least tone deaf, to the harsh reality of what the criminal justice system is. Every single day, we see a person plead guilty. Sometimes a person is found guilty. People are sentenced to horrible sentences. People are sentenced to prison. People are separated from their families. But know this. This is the only trial my client will ever have. We don't want part of your attention. We want all of your attention. We don't want part of your focus and your commitment and your obligation and your sincerity and your mental horsepower. We want all of it, because this is the only trial my client will ever have. You can go from there. Remember the obvious things. That is, humanize your human, meaning make sure that the jury understands that you have genuine compassion and genuine care for your client. And they'll sense that. They will sense that a mile away. And if you're dismissive, even in a private moment with your client, slap his hand away, or if you push a note away, or if you separate yourself from him during a cross-examination or a direct, the jury's going to sense that. Juries, look, When you boil it all down, most of the numbers will tell you that the average educational rank or level of a juror is probably a freshman or a sophomore year in college, right? We got people with little education, we got people with great education. Of course, it varies from jury to jury to jury. They're not always the smartest. They're not always PhDs or MDs. But one thing a jury is they are a great bullshit detector. They can smell bullshit from 1,000 miles away. If you're not sincere and you're not honest, you are not projecting like you care about your client, they're going to know that. So recognize that. Humanize your human and make sure a jury understands you give a damn about your client. Embrace the suck, I say. What does that mean? This is a difficult job we have. It just is. So the idea that it's going to be an easy decision for a jury to find your client not guilty, it's never easy for a jury to find somebody not guilty. It's just not. You need to acknowledge that in your final argument. You need to say something along the lines of, no one ever told you that being a jury was easy. No one ever told you that coming to the right decision would be quick or easy or painless. It's not. None of this is quick or easy or painless or inexpensive. It's not for me, not for my client, not for you, not for anyone. But you must know at the end of the day that what you do, the hard decisions, the good decisions are always the hard decision. It's not easy to find a person not guilty, but it's the right thing to do in this case. So I'm asking you to make that hard decision, to make that right call, and to find that there's a reasonable doubt and find my client not guilty. Don't forget the obvious. I just talked to them about the presumption of innocence, burden of proof beyond a reasonable doubt. Sometimes we get so wound up in our final argument, those pillars of the criminal justice system just kind of evaporate in the midst of a final argument. Don't let them. Reasonable doubt, that is the cornerstone of the whole entire criminal justice system. And what it means in the federal definition is proof beyond a reasonable doubt is proof of such a convincing character that you would be willing to rely and act upon it without hesitation in the most important decisions of your own affairs. Look, that sounds really good to me. That may sound pretty good to you if you're a lawyer, but a layman looking at that is thinking to themselves, what the fuck does that mean? It's a bunch of words strung together that with no real world explanation or application to how to explain it or understand it. What I try to do is give a jury a visual interpretation of the different standards of proof. It's perfectly legitimate and perfectly appropriate, but here's what I do. I give them the whole stair step, that old tired, visual that every lawyer in the world, no evidence, scintilla, reasonable suspicion, probable cause, preponderance, clear and convincing, reasonable doubt. Again, that's a cool visual. It's been used a gazillion times in every criminal courthouse in America. But how does that really help a person differentiate what is necessary for an arrest and what's necessary for convictions? So what I try to do is give them an example. The first example is something along these lines, and telling them again, it's without hesitation, the most important of your own affairs. But I give them something along this. If probable cause was a house, and let's refresh ourselves. Probable cause is the amount of proof that an officer must have before he makes an arrest. That's all an officer had to have before my client was arrested. That's all a grand jury had to have before they indicted him. Just probable cause. So if probable cause was a house, I suggest, it would look something like that. The next level of proof up is preponderance of the evidence. That's what they use over in the civil courthouse. That's what they use to decide whether or not a person is held liable for for monetary damages. We hear about these $100 million verdicts or these $2 billion verdicts, about these monster verdicts. Well, they are based upon the idea that the plaintiff in that case has to prevail by a preponderance of the evidence, a 50.5% versus 49.5%. So if preponderance of the evidence was a house, it would look something like that. The next quantum of proof is clear and convincing evidence. So that's the amount of evidence CPS, if they were going to come into your house and take your children away, 1, 2, 3, or 4 of your children away, that's the amount of evidence CPS would have to show a judge to prevail, to take your kids away from you. So if clear and convincing was a house, it would look like that. But we're not talking about preponderance. We're not talking about probable cause. We're not talking about clear and convincing. We're talking about the highest standard of law recognized anywhere, and that is proof beyond a reasonable doubt. So if proof beyond a reasonable doubt was a house, it would look like that. The point is this: what is needed for arrest is vastly different than what is needed for conviction. So again, you don't have to use a house. You could use a horse. You could use a boxer. You could use, whatever. But I think a visual demonstration of the difference in the quantum or the amount of proof between what's needed for an arrest and what's needed for conviction, you should always give a jury an explanation or an assimilation or an analogy that's not just words. Give them something to look at. To me, that's very effective. I think a jury can get it when they see that shack versus that house. Know how you're going to end. We can go into perhaps in another format, but I like to end with something like that, something like this rather. I call them the give them back to me argument, and it goes something like this. When Kerry Birmingham came to me 2 years ago, he gave me his future. He gave me his liberty. He gave me really his ability to continue to vote, his ability to continue to hold down a job, his ability to continue to work, continue to be a productive member of society. He gave me his entire life, and I'm trying to do everything I can to effectively represent him. I did the discovery. I did the due diligence. I've met with witnesses. I've done my best to prepare for trial, done my best while I'm in trial. But here's the thing. I'm giving Kerry Birmingham to you. I'm giving you his future, his past, his ability to provide, his ability to be an effective person, his ability to be a father, his ability to be a grandfather, his ability to stay a free person, for God's sakes. He's giving that burden to me, or gave that burden to me, and now I'm giving that burden to you. And I want you to promise me that you will give him back to me, that you will look through the evidence, that you will require the state to prove its case beyond a reasonable doubt, that you will not have any hesitation to act. You will not have any hesitation in believing that the state has met its proof. Because if there is any hesitation at all, if the government has failed in their burden of proof, if the government has not proven their case beyond a reasonable doubt, I want you to give him back to me. It doesn't mean that he's a great person, that he's never made a mistake, that the prosecutor's not effective, that the judge is unfair, or that the cops lied. It doesn't mean any of that. What it means is nothing more or nothing less than you have a reasonable doubt that goes to one of the elements in this case. That's all it means. So I'm giving him to you, and to you, and to you, and to you. And I'm asking you, by your verdict of not guilty, to give him back to me and his family. Thank you. So there's different ways to end it. That's just one of 100, but I hope that helps the young lawyers out there.